Despite the many differences between positive law and fictional imagination, a joint characteristic of the law and literature is that they are both text-based. Law, like literature, is textual. Law, like all text, literary and otherwise, therefore requires interpretation. This view of law as literature is essentially a hermeneutic or interpretive in its essence. This means that we see the legal text, constitutions, laws and regulations, court judgments, contracts, etc., as a form of literature, and we employ literary criticism and analysis in order to better understand the law. According to this approach, law as literature can benefit from techniques employed by literary critics in order to decipher the meaning of the legal text. If that is right, then whatever we might know about the nature of interpreting literature might be usefully applied to the task of understanding the interpretation of the law. And whatever might be true of the relation of author, reader, and text in literature might likewise be true of the relation of author, reader, and text in law. What can be learned from this comparison? The main insight that legal scholars borrowed from the critical theories of the late 20th century was that the task of interpreting a text to discern its meaning cannot be a matter of simply delving into the mental state of the text's author, the legislator, the drafter of the Constitution. The meaning of a text, any text, from a novel like Moby Dick to a contract to a judicial opinion, cannot be simply equated to what the author of the text intended. But if the meaning of a text is not the meaning intended by the author, then what is it, and how should one ascertain it? The understanding that legal texts can benefit from critical reading against the grain of the author's intent led to a rise to prominence within law schools of literary theories like deconstruction or post-structuralism that challenge the relationship between text and meaning. Deconstructivist theories, for example, called to read text counter to the intended meaning or structural unity of a particular text. Post-structuralism approaches argue that in order to understand the text, we must study not the object itself, or not only the object itself, but the systems of knowledge that produced it. The turn to literary theories and methods of interpretation meant that the meaning of a text in law, as elsewhere, is to be found not in the author's mental state and not in the text itself, but in the community of readers that generate it, or in the reader's mind, or in some interactive process between text and the interpretive community. Wherever one locates it, the process of generating meaning, according to such critical theories, is governed by the community's norms and principles governing interpretation. In other words, literary hermeneutics promised liberation of the law and of the legal text from its bondage to an archaic text and to the dead white man that drafted, dominated, and haunted the legal texts. Legal scholar and literary critic Stanley Fish, in his famous essay, Is There a Text in the Classroom?, argued that the objects, texts, and facts with which every enterprise works are real in the only way that anything is real. And the knowledge that we possess is therefore secure in the way that all knowledge is secure, by virtue of its acceptance within a community of interpretation, whose existence is a prerequisite to the production of knowledge itself. These radical assertions about the subjective nature of knowledge and of law itself did not go unchallenged. One example for such backlash was presented by constitutional scholar Owen Fiss, who warned against the nihilism in literary theories that threatened truth, objectivity, and reality itself. Posner's diatribe against the interdiscipline offers another conservative, right-wing critique reacting to the threat to truth he saw posed by the left-leaning proponents of the law and literature. The interpretive turn in literature questions the status of law as a science. It challenges core ideas of the 20th century legal education and profession that saw the law as a scientific endeavor and legal interpretation as objective. This interpretive turn was not free from political motivation. It sought to open up new spaces within the legal realm for alternative interpretations of the law, feminist, Marxist, identity politics, and other voices of the critical legal studies movement. These radical shifts from perceiving the law as a science, to thinking of law as art, to understanding the law as a narrative to be interpreted will be further discussed in the unit on law and narrative.